Hey there, and welcome to a very special training called Setting the Stage, Preconditioning the Officer and Providing the Roadmap to Get to Yes. Now, what is this training all about? Well, we're going to make the asylum officer love you and your case before you set foot in their office. We're going to ensure they have a great opinion of you and that they think favorably about your case. We're going to get your interview started off on the right foot by making the officer's job easy. We're going to give them everything they need to know about your case and why exactly you are eligible for asylum before your interview. And we do that by setting the stage with a supplemental filing, which I sometimes also call a supplemental submission. Before we jump into the tactics, let me provide briefly some context so that you'll understand why this is so important and why, if done well, this supplemental filing can be so powerful. You see, asylum officers get a person's case file ahead of time and they review it so that they can go into the interview prepared. They normally come up with an outline of questions ahead of time, and they may do research about the conditions in your country so that they're better prepared. They review the asylum application form and they will review the personal statement you submitted if you did in fact submit one. By the way, this personal statement is sometimes referred to as a written statement or a declaration or a history. All those terms get used to describe the same thing, a statement that an asylum applicant writes and submits for their case that explains what has happened and why they're afraid to go back to their country. If you submit evidence with your case, the officer will review it too. Evidence can be things like letters from witnesses or documentary evidence like a medical report from a hospitalization after you were attacked, or photos of your injuries, or perhaps a letter from a mental health professional whom you've seen to help you deal with the trauma you endured, or maybe even threatening text messages. Now, if you submit reports about what's going on in your country, like news articles or reports from nonprofit organizations or other governments, the officer might look at them, but for reasons I'll detail in a minute, they probably won't spend much time on this unless you package it in a certain way, which I'll let you know how to do in just a minute. By the way, we call these reports collectively Country of Origin Information, or COI for its acronym. You may also hear this referred to as Country Conditions Information. So in summary, these are the main things that people sometimes submit and which the officer should review before your interview: the asylum application, personal statement, evidence, and country of origin information. Now, collectively, we'll call these items beyond your application the written materials for your case. So in this training, when I use the term written materials, I'm referring to the personal statement, evidence, and country of origin information. Note that there is one more additional element that I recommend that you provide to the asylum office before your interview, which is a timeline. Now that's slightly advanced and I cover it in a separate training. Okay, so when the asylum officer is well prepared and when they understand the nature of the case and its key aspects ahead of time, the interview itself is more likely to go well and just be easier for the officer to conduct. So when you do a good job with the written materials, you're helping yourself out immensely. But when the asylum officer does not have much to go on because the applicant didn't do a good job with their written materials, then the interview can be much more of a slog. So if you don't provide all the elements we listed that make up the written materials, then you're not maximizing your chances for success. But this is true that you're not helping yourself out, even if you do submit them, but you do a poor job with the written materials. And this happens all the time. People often submit all the elements we listed a second ago, but they're poorly done. Most asylum applicants, including smart, sophisticated applicants like you, don't know how to do this in a way that will truly help their case. The written materials are poorly done, both in terms of the substance and their packaging. So when this happens, when someone either doesn't submit all elements of the written materials or they do so, but it's poorly done, the officer will have to basically start from scratch in analyzing your case. They'll have to do much more work before the interview to prepare for it. By not doing a good job with the written materials, you're creating more work for the officer. And trust me, you don't want to do that. Then at the interview, they have to ask questions about baseline stuff that could have been easily addressed in a person's written materials. And having to ask these questions takes time. It's tedious and it's frustrating for the officer. It can take the officer an hour or more just to get a sense for what kind of case is in front of them before they're able to turn the focus to issues that really matter to their decision. And that's annoying for the officer. You don't want to annoy the officer. In fact, everything you do in pursuing your asylum claim should be geared to make the asylum officer's life as easy as possible. You see, the job of an asylum officer is hard. The workload is intense, and the nature of the work is emotionally taxing. It's actually a really stressful job. In fact, most asylum officers don't last more than a couple of years in this role, and this is because it's hard. And most applicants are disorganized and don't know how to present a case in a way that makes the asylum officer's life easy, that makes for a case that makes the officer say, yes, finally, a nice, clean case, where I know exactly what the issues are and I know exactly what I need to do to prepare to interview this person. And I also have a good idea for where the interview is going to go and even for the decision I'll probably end up making. And to be honest with you, it's really not much different for asylum applicants who have a lawyer. I was shocked when I was an asylum officer to see just how little most immigration lawyers did to actually help their clients. Cases of clients with a lawyer were seldom better prepared than cases of people without a lawyer. I found that most immigration lawyers actually know very little about asylum law. It's a complicated niche within immigration law that, frankly, most immigration lawyers don't take the time to master. And even more frustrating than the lawyer's lack of knowledge was their lack of effort. Most did virtually nothing to help their client present a good case. Most just help the person fill out the application form. I assure you, that is not enough to give yourself the best possible chance for success. Now, here's the good news. Expectations are low. What do I mean by that? Well, the fact that most people leave the asylum officer in the dark with their written materials means that you'll stand out even more if you give the officer ahead of time what they need to understand and prepare for your case. I assure you, you'll be judged in comparison to other applicants. If your written materials are even objectively decent, well, they'll seem outstanding to the officer who is used to seeing either nothing from most applicants or written materials that just aren't helpful. You see, asylum officers are human, and if you make their life easy, they'll be inclined to view you more favorably. You can go in to your interview with the asylum officer liking you and your case because you essentially did much of their job for them. You showed them ahead of time what they needed to see, and you packaged it in a way that makes it clear exactly why you are eligible for asylum. I'm telling you, when I was an asylum officer and someone came before me with a well-prepared case that made my job easy, I believe I was more inclined to give them asylum. Now, I'm not saying that's how it should be, but that's how it is. Because you see, asylum officers are human. They're subject to emotion and human psychology. If you make them like you by presenting your case in a way that makes their life easy, this can't help but move the needle in a favorable direction. Now, to be clear, I'm not saying that if you just submit the right documents in the right way, you'll definitely win asylum. But I do honestly believe that you can gain an advantage by doing this the right way, by both providing the right information ahead of time and by predisposing the officer to view your case favorably. And that's the goal with what I call the supplemental submission that you can do. It's to precondition the officer to like you and your case, to move them toward the answer yes before you even set foot in their office. Now, used as a verb, the word precondition means to condition an action to happen in a certain way. The idea is that you can lay the groundwork, you can set things up in a way that makes a given action more or less likely to happen. You can influence a decision by what you do ahead of time. So, applied to your asylum interview, you can precondition the officer to want to grant you asylum by making them like you and understand your case before your interview ever takes place. When I was an asylum officer, on the rare occasion when someone set forth clearly ahead of time exactly what I needed to know about their case, and they did it in a way that was concise and easy to consume, well, I went into their interview with a wholly different mindset than when an applicant did a poor job with their written materials. The question then is, how do you give the officer what they need ahead of time so they will understand your case and see that you're eligible for asylum? How do you get them to go into your interview thinking, I know what this case is about, I'm prepared for it, and I even think that as long as this interview goes in the way that I expect it to go, I'm probably going to give this person asylum? Well, for people who have already applied for asylum and are waiting for their interview, we do this through the supplemental submission, also known as the supplemental filing. And this is a packet that you're going to send to the asylum office for inclusion in your case file, so the officer assigned to your case can review it before your interview. There are 3 core elements to the supplemental filing, and they are, you guessed it, the written materials I talked about earlier. 1, a short written statement. 2, country of origin information. And 3, evidence. We're going to now cover each of these. I'm going to tell you what to do for each of these 3 elements and then how to package it up and send this filing. Now, before we jump into the first element of the supplemental filing, the written statement, let me just say that I believe you should do the supplemental filing even if you already supplied these elements back when you applied for asylum. Yes, that's right. Even if you submitted a personal statement, evidence, and country of origin information concurrently with your asylum application, you're almost certainly going to want to do a supplemental filing that contains these same elements. Now, why is that? Well, you didn't know then, back when you applied for asylum, what you know now. Now that you're doing my trainings, you know what the asylum officer really needs to know about your case, and you're learning how to give this to them. You're in a much better position now to set the stage with documents than you previously were. In short, it's a near certainty that there's a lot of room for improvement in terms of what you already submitted. Okay, you ready to get started with the 3 elements of the supplemental filing? Great, let's do it. So element 1 is the written statement. Odds are that you did not adequately address all elements of the CHIPS framework in your application or the personal statement that you may have submitted with it. If you don't know what I'm talking about when I refer to the CHIPS framework, then please go take my training called the CHIPS Framework for Asylum Success. It really is foundational. You need to know it to build the strongest asylum case possible. Now, understand that it's perfectly normal for the written statement that you previously submitted to be inadequate. Almost no one does this properly without having the benefit of the kind of trainings that you're watching now. The written statement that's part of your supplemental filing is your second chance. If you submitted a written statement previously, this new one is kind of like a do-over. Only it's not meant to replace whatever you submitted with your application materials. It's meant to supplement them. It's your chance to go back and succinctly address the elements of the CHIPS framework, especially the parts that stand for harm, intent, and protected ground. You'll write a document that is not more than 3 pages, single-spaced, in which you recount incidents of harm, anything that has happened, or any general circumstances that indicate that you're likely to be harmed in the future, and which also show why someone would harm you. What is it about you that makes them want to harm you? And in this statement, you'll be sure to frame things in a way that's consistent with your prior representations made in your application materials so that there aren't any credibility concerns. Now, if you realize you made an error in your prior submission, it's okay. Don't repeat the errant information in your supplemental filing just for the sake of trying to be consistent. Rather, explain in your new written statement what the error was in your prior filing, and also explain in just a sentence or two what the error is attributable to. For example, if you said in your prior statement that you received 4 threatening calls, but you realized that this was a mistake and you in fact received 8 such calls, well, you'd want to address this in your new statement and say why you errantly indicated previously that there were just 4 calls. For example, was the errant 4 actually just a translation mistake? Did your original statement, which you wrote in your own language, say 8, but the translator accidentally put 4 in the English language translation? If so, just say as much in your new statement. Remember, honesty is the best policy. Be honest and open, okay? Oh, and by the way, if you're not sure what all was in your prior submission, like because you failed to make a copy of everything, or maybe you did but you lost it, then you should do a Freedom of Information Act request to ask for a digital copy of your entire immigration file. You'll definitely want to review everything in it very carefully as you craft your supplemental filing. To make one of these requests, you can just Google USCIS FOIA, and the result that you're looking for should be the top one, which looks like this. So you click on it, and then on the next page, scroll down a bit and click on the green button that says Request Records from USCIS, and then just follow the prompts to request a PDF copy of everything USCIS has in your file. Okay, so what else is going in your new written statement? Well, you'll use it to address head-on anything in your history that could suggest you're a security risk. It's better, in my opinion, to be proactive and raise such issues yourself than it is to play defense, waiting for the officer to possibly confront you over it during your interview. So, do you need to explain why you're submitting this personal statement as part of your supplemental filing? Well, if you did not submit a written statement with your application materials, then at the top of this statement we've been discussing, you can say something like, I'm writing to tell you why I'm applying for asylum. I'll be glad to provide more detail at my interview, but wanted you to know ahead of time some of the main things that have happened that make me fear I will be harmed if I have to go back to my country. And by the way, I'm not saying you should use that exact language. In fact, you should not. The language you use should be your own. Your statement needs to be 100% your own words. I'm just giving a suggestion on the sentiment that you may want to consider trying to convey. Now, if you already submitted a personal statement, then you could consider something along these lines at the top of your supplemental written statement. I'm writing to provide you information about my case that I believe may be important for you to know. I included some of this in the personal statement I submitted with my asylum application, and now wish to provide more detail about some of the things in that statement for the purpose of helping you understand my situation. If you previously submitted a personal statement, then the goal of this supplemental statement is to condense everything down into a short statement that the officer will actually read and which is easy to consume and which addresses only things that are relevant to the asylum decision. Now, having seen many personal statements as an asylum officer, I believe I have a good sense for what makes for a good one and for what is not helpful. And I promise you, if you do this well, it can make a huge difference in your case. Your written statement can serve as a roadmap that will show the officer how to get to the answer yes in your case. So, how do you do this? How do you write a succinct, compelling declaration that gives the officer the information they need? How do you show them, before you set foot in their office for your interview, that you should be granted asylum? Well, this is what I teach in detail in my training called The Perfect Personal Statement. And that's where you need to turn for the step-by-step guidance on how to craft this very important document. So watch that training. In fact, watch it twice. Have it out while you write your new declaration and go part by part to ensure that you follow my guidance as closely as possible. Now, notice how I used the word guidance. That's what my training on the personal statement is. It's advice for the overall framework and the key elements you should address in your statement, but it's definitely not actually me doing your statement for you. Only you can do that. In fact, unfortunately, I don't feel like I can provide you even a sample personal statement. Why? Because the asylum office is incredibly uptight about personal statements. They sometimes ask multiple questions about how you went about writing your statement, including sometimes whether you looked at any samples or templates. They seem to think that it would be inappropriate to do so. I completely disagree, and I think that immigration judges have a very different view on written statements. You see, in immigration court, it's normal for lawyers to write their client's entire declaration after the client tells the lawyer their story. That's acceptable in immigration court. But in the asylum office, for some reason, officers seem to think that you have to write every word on your own and that getting any case-specific input or looking at a sample or template is something bad. And I don't want to put you in an awkward position if the officer asks whether someone helped you with your declaration. For that reason, I don't advise people who aren't my clients on the specifics of their declaration, and I don't provide any kind of sample or model for them to look at. And by the way, I urge you not to commit immigration fraud. It's tempting to do this with your statement. It's tempting to just go buy one from someone on WhatsApp or whatever, but please don't do that. Don't copy from someone else and don't make things up or exaggerate. Promise me that, okay? Do this the right way. All right, that covers what we needed to cover in the present training on the written statement that you'll submit with your supplemental filing. So we're ready for the next element. Now, the second part of the supplemental filing is country of origin information, referred to within the asylum office by its acronym COI. COI refers to reports, news articles, and the like about your country that support the things that you need to establish to win asylum. Now, it's probably not the case that you yourself are personally mentioned in any press reports or other kinds of reports, but that's okay. Information about the conditions generally in your country or about specific events that might not be specific to you can be useful for convincing the asylum officer that you meet the criteria for asylum eligibility. To be clear, you're not obliged to find a news article or report from a non-governmental organization talking about an attack on you. That probably doesn't exist in your case, right? Well, not a problem. That's normal. The officer doesn't expect you to produce this. Now, if there's a witness to this incident who can write a letter about it describing what they saw and heard, then that's great. Do include with your supplemental filing such a letter, but that's not country of origin information. Rather, that's evidence. And COI and evidence, which we'll talk about in just a second, are two different things. Evidence is support that's specific to you and your circumstances, as where COI is, as its name suggests, information about your country. So, what's an example of where COI can be especially useful? Well, it's important where you have not been severely harmed in the past, but you fear you could be in the future. You can use reports and articles to show that the people you fear, whether it's the government or private citizens, are doing bad things to people like you. In other words, you can show that people who are similarly situated to you are being persecuted on account of one of the protected grounds, so there's a real chance that you too will be persecuted. Does that make sense? Well, let me give you an example. Let's say a person who is gay was not open about their sexual orientation while they were in their country, but then they come to the United States and they embrace their identity and they come out and they begin living openly as a gay person. Well, perhaps nothing bad ever happened to them back when they were in their country, but that's really because no one knew they were gay back then. Now, people in the person's home country know about it because of the person's social media and because they're open about it, and they would want to live openly in their identity if they had to return to their country. Well, nothing bad has happened, and this person has not been threatened, so there's no reason to believe they're on someone's list for harm. No one back in their country is thinking, oh, I can't wait until so-and-so gets back here. We're going to teach him a lesson. Rather, the fear here is based on what we know about how gay people tend to be treated in this country. We know that just being gay in this country is enough to put someone at serious risk of harm. How do we know this? And more importantly, how do we convince the asylum officer of this? Through country of origin information. That's how. We point to credible reports showing that persecution of members of the LGBTQ+ community is widespread, that people in this community are treated terribly, and that it's dangerous to live openly as a sexual minority in this country. An Iranian who converts from Islam to another religion once in the United States would be in a similar situation in that their case would be forward-looking. It would be based on their fear of future persecution and not focused on harm in the past. And it would be reliant on country of origin information to show that they qualify for asylum. Another example is people from Afghanistan who worked with or supported Western militaries or governments or worked for the former Afghan national government before the Taliban took over the country again. Just fitting this profile is enough to put them at grave risk. And the way that we show the officer that this is true, that this person legitimately may be persecuted, is through COI that shows the Taliban routinely targets for harm people fitting this profile. Okay, so that's one type of case where COI is especially important, where you're claiming that you're at risk just because of who you are, just because you possess one of the protected characteristics, and people like that get persecuted frequently in your country. In what other circumstances is country of origin information really key to your case? Well, COI is crucial in cases where the government is not the persecutor. By that, I mean the person or group that is persecuted or may persecute you in the future does not work for the government. Like they're not officially part of a government agency, but rather are private actors. They're private citizens. So in many asylum cases, the bad guys are the police or members of the military, and they're acting in an official capacity and harming people. In such a case, we would say that the persecutors are government actors. It's the government doing the persecution. But in many asylum cases, the bad guys are private actors. They're people who don't work for the government. These can be gang members, militias, or just any random civilian. In fact, it can be people you know in your community or even your own family members. Thankfully, it's still possible to win asylum when the persecutor is not from the government, but it's a little bit harder. You've got to take an extra step to establish your eligibility. In this case, you have to show that the government is unable or unwilling to control the feared persecutors. In other words, you need to convince the asylum officer that the government either essentially tolerates the persecution or is so overwhelmed and outmatched that it just can't do anything about it. The idea here is that if you could just go report the bad guys to the police or other competent authorities, and they could reasonably be expected to take effective action to keep you safe, then you don't really need asylum in the United States. You could be safe, more or less, in your home country. So the United States isn't going to give you asylum. But U.S. asylum policy recognizes that people other than the government can and do persecute others, and that sometimes the government just isn't in a position to help. We've decided that victims in this position should still be able to get asylum. But for you to win asylum under these circumstances, the officer has to be convinced that the authorities in your country are unable or unwilling to help people in your position, people who've been harmed or at risk of being harmed for the same reasons that you're being persecuted. Now, how can you convince the officer of this? Well, if you've had personal experience with it or have personal knowledge of someone else who has, this is relevant and you should talk about it in your written statement and, if possible, provide evidence concerning it. What do I mean by that? Well, if you went to the police 3 times after being physically attacked by a family member, and the police just said, sorry, we can't help you, sounds like a matter that should be settled within the family. Well, this is important to your case because it shows the authorities are unwilling to even try to help you. You need to make the asylum officer aware of this. But there are lots of cases where an asylum applicant does not have personal experience that shows that the authorities are unable or unwilling to help them. And that's where COI comes in. And even where you do have personal experience, like perhaps you've been through something along the lines of the example I just gave, where the police said, sorry, can't help you, it's still a good idea to show with COI that the authorities can't be relied on to help people like you. This is because the officer may think, well, you could just go to some other authorities. You went to the local police station, but I bet if you went to the federal authorities in the capital or went to some other law enforcement entity, I bet they would help you. You can push back against this mode of thinking with COI that shows that the problem is pervasive and perhaps even countrywide. COI that shows that the harm you fear occurs all the time, and so it's obvious that the authorities aren't able or aren't willing to really do much about it. The person in the example I just gave would want to show the officer with COI, if possible, that their bad experience wasn't a one-off isolated incident. They would ideally be able to find COI saying, or at least indicating, if not explicitly saying, that this kind of thing happens all the time. And you can sometimes find reports that say that the authorities in a given country more or less refuse to respond to certain kinds of persecution, or that they're overwhelmed and just can't get the problem under control even if they wanted to. Country of origin information showing that the authorities in your country are corrupt can also be helpful. The asylum officer may think, well, yeah, I know that those 2 police officers are harassing you and have threatened you, but I bet you'd be fine if you just reported them up the chain at their police station, or if you went to a different police station or different law enforcement entity. If you can find COI that paints law enforcement as broadly corrupt, like saying, for example, that law enforcement and other government officials break the law with impunity, then this can help your case. For the clients at my law firm, I usually include COI along these lines, showing how corrupt and generally ineffective the security apparatus is in a country, even where the persecutor is the government. I want to paint a picture of an environment in which the authorities simply cannot be counted on to help my client. We've discussed using COI in cases where you need to show that you're at risk of being persecuted just because of who you are, and in cases where the persecutor is a private actor. Under what other circumstances can country of origin information help you? Well, if you have been harmed or threatened in the past, it can help you prove the point that the people who did this to you are likely to harm you again in the future, and perhaps in a way that's even more severe than what's occurred in the past. COI may help you convince the asylum officer that the feared persecutors are likely to carry out their threats against you, because we see in reports that once someone is on the list of these bad guys, well, the bad guys really do follow through. They harm people like you so often and so severely that there's every reason to believe they will in fact persecute you in the future. You see, COI can help show that threats you may have received are not hollow, that the bad guys mean business when they decide that they don't like someone. Now, we can see this, for example, in Venezuela, where people who oppose the government are often targeted for harm by the government or its supporters. Sometimes a person will have had a conflict with the government or its supporters and may have been harmed, but not terribly gravely, and may have received some threats. And in that kind of case, the asylum officer may think, you know, what happened to you is bad, but it's not that bad, and those death threats seem like they're just words. I'm not convinced the bad guys really do intend to kill or otherwise gravely harm you, because they made those threats quite a while ago, and you hung around in your country for a while afterward, and they never went through with killing or otherwise persecuting you. So, in other words, the officer thinks it's all talk. The officer thinks the feared persecutors are not serious about persecuting you in the future. Well, COI can help show that the bad guys do terrible things to people whom they've deemed to be political dissidents so often that it's reasonable to conclude that they likely will, in fact, carry out their threats eventually. The idea is that, look, reports show us that once someone gets on the list of these bad guys, it's only a matter of time before the bad guys do something extreme. So the fact that they didn't act on their threats in the past does not mean that they'll never act on them. We see from the COI that the bad guys do, all the time, end up doing the kinds of things that they've threatened to do. Importantly, COI can also help show the motive of the persecutors. Remember, you need to show that they're motivated, at least in significant part, by the fact that you possess one of the 5 protected characteristics under U.S. asylum policy. And if the motive is not entirely clear from the words the persecutors have used in your case, or from the particular circumstances of your case, then COI may help convince the officer that, indeed, the persecution is happening because of the fact that you possess a protected characteristic. So, for example, if you suspect that the bad things are happening because of your religion, but there's nothing concrete you can point to in terms of the persecutor saying something about your religion, well, it would be helpful to point to COI that shows that the people you fear are harming victims of the same religion as you, and that there's no indication that the persecutors are harming anyone who is not a member of your religion. Okay, I'll give you a couple more examples of the kinds of circumstances where COI can be especially helpful, and then we'll turn to how to find the right COI and how to actually use it. COI can be helpful to show that there's really nowhere in your country that you could go to avoid future persecution, that you really wouldn't be safe anywhere in your country. This is especially important where the persecutor is a private actor and not the government. The asylum officer will expect you to explain why you couldn't just move within your country to some other place and be safe. Your job becomes easier if you can point to COI that indicates that persecution, of the sort you fear, occurs not just in isolated places in your country, but rather throughout it. COI can also be crucial in cases where the asylum applicant was in another country after leaving their own country but before entering the United States, and they had some kind of legal immigration status in that third country. If your immigration status in the third country is even arguably permanent, then it can help to point to official sources from that country to convince the asylum officer that this status was not, in fact, permanent. This can be tricky. It involves analysis of the third country's immigration policies, so you may want to have a lawyer from that country help explain in writing for the asylum officer how the status that you had works exactly and why it should not be considered permanent. Okay, a really important note on COI. You need to use credible, authoritative resources. By that, I mean to emphasize that you can't just point to any old report or statement that you find online and expect it to influence the asylum officer. Everyone knows there's a lot of bad reporting and biased sources out there. The asylum officer will likely give less weight to COI from sources that they're not familiar with. And officers are actually trained to use certain resources in doing their own country of origin research, which they're supposed to do for every single case. Just to give one example, officers routinely use and will trust the annual human rights report that the U.S. Department of State issues for each country. That's widely considered to be an authoritative source. Probably the easiest way to find it is to Google state.gov human rights report and then the name of your country. You should see it at the top of the search results. The report's formal name is Country Reports on Human Rights Practices. It looks like this. Notice how in the lower left-hand side of this screenshot it says 2021 Country Reports. That's the link that will take you directly to the most recent version of the Human Rights Report. Note that they're behind a bit. You'll never see a report that's for the year in which you're actually searching for the reports. New ones usually come out in the spring and they cover the previous calendar year. So when we click on that, it takes us to a page that looks like this. And over on the right, I'm going to click on the drop down for select a location. And then you can either scroll down to find the country that you want the report for, or just type it in the little box and click on the name of the country when it appears. Let's say, for example, that I click on the country Eritrea. What happens next? Well, you're taken to the 2021 Human Rights Report for Eritrea, which looks like this. The report for Eritrea is 26 pages. Reports for some countries are shorter, while they're longer for others. They're divided up into various sections with an executive summary up top giving you an overview. There's often very helpful language in this summary. Let me give you an example of how this works. Let's say someone from Eritrea was arrested and detained by the authorities who threatened that while the person is going to be let go this time, if the authorities ever see the person again, they're going to lock them in jail, throw away the key, and do unspeakable things to them because the person deserves it for opposing the government. Well, there's plenty of language in this summary supporting the proposition that this is indeed likely to happen, that the Eritrean authorities commit grave human rights abuses, including against people they perceive to be political dissidents. For example, in the executive summary, it says that Eritrea is an authoritarian regime where members of the security forces committed numerous abuses. Moreover, the Eritrean defense forces were responsible for widespread and serious human rights abuses, including execution, rape, and torture of civilians. Also, on the next page, at the end of the executive summary, we see that the government did not generally take steps to investigate, prosecute, or punish officials who committed human rights abuses. Impunity for such abuses was the norm. This sounds like the kind of country where the threats that our hypothetical asylum applicant received will in fact be carried out, doesn't it? There's lots in what follows that's relevant to someone like our hypothetical applicant who has been threatened with imprisonment. For example, the report says an unknown number of persons disappeared during the year and were believed to be in government detention or to have died while in detention. And then a little further down, it says that reports of torture continued, especially against political prisoners, which is exactly what our hypothetical applicant could become. Further down still, there's a section on prison and detention center conditions, where the report says that detention conditions reportedly remained harsh, leading to serious damage to health and, in some cases, death. The report goes on and on like this. It sounds pretty terrible, right? Also relevant to our applicant, it says authorities placed political prisoners in solitary confinement more often than other detainees. Political prisoners were thought to be more likely to be held in the underground cells. Now, all of this helps the officer understand just how bad things are in Eritrea for people whom the government views as political opponents and whom it detains. So we can see that there's lots of helpful stuff in this report. The question then is, how would you use it? How do you package it and relay it to the officer? Because here's the thing. You cannot just print out this report or any other source of COI, plop it into your supplemental filing, and expect it to make an impact on the officer. I promise you, if you just submit a 60-page report or even a shorter one like this report on Eritrea at 26 pages without directing the officer's attention to the exact part that's relevant to your case, it will not help you. They just don't have time to deal with this. They're not going to comb through and find the relevant parts, the ones that support your case. You see, that's your job. The best way to maximize the chances that the officer will actually see what you want them to see is to reference the exact relevant language from the report in your written statement, stating what page it's on in your supplemental filing, and then to literally highlight the relevant language in the report. For example, in our Eritrea example, the applicant could discuss in their supplemental written statement the threat they received like this. Right before they released me from detention, the military man said to me, "You're lucky, you're getting off easy this time, but if we ever see you again, we're going to lock you in jail, throw away the key, and do unspeakable things to you because you deserve it for opposing the government. I fear they'll make good on this threat, as they very often do in fact detain, torture, and even kill people whom they view as being against the government." The U.S. Department of State references in its most recent human rights report for my country that there were reports of torture, especially against political prisoners. The report also says detention conditions reportedly remain harsh, leading to serious damage to health and, in some cases, death. The State Department report discusses torture at page 3, which you will find at page 6 of my supplemental filing, and it discusses prison conditions at page 4, which is located at page 7 of my supplemental filing. So that's it. That's an example of how you could use COI to support your case. Notice that in this example, I did not include a formal citation, but I did tell the officer where they could find the language that I was quoting. I think that's the best way to handle this if you're doing this without a lawyer. And by the way, if you do hire a lawyer, they should do all the COI work for you and should discuss and reference it in their legal brief. You should not discuss or cite to COI in your written statement if you have a lawyer. But most of you watching this are proceeding without a lawyer, so I wanted to show you how, on your own, you can leverage COI in support of your case. Notice that I told the officer both what page of the actual report the referenced language was found on and on what page of my supplemental filing it's found. Now, what do I mean by that? Well, ideally, you should paginate your supplemental filing. So what does that mean? Well, everything after your cover letter should be numbered in sequential order, and there should be, right after your cover letter, an index that shows you on exactly which page everything is located. So if the order of my supplemental filing is cover letter, written statement, country of origin information, and then evidence, the first page of my written statement will be page 1. If it's 3 pages long, it'll be pages 1 through 3. Then page 4 of my supplemental filing will be the first page of the next element, which is the COI, and so on. So it might look something like this. In this example, the personal statement starts at page 1, and then there are 2 different COI pieces starting at pages 4 and 9. Then the evidence starts at page 16 of the packet, with a second evidence item coming at page 17. This makes it easier for the officer to find the information they're looking for in your supplemental filing. They can quickly jump back and forth between your personal statement and the COI or evidence. Having your filing be paginated with an index included makes things easier on the asylum officer, and we want to make their job as easy as possible. Now, How did I create this? Well, I used a software called BundleDocs, and you can find it at bundledocs.com. But there are other programs where you can do this, like Adobe Acrobat. You can even do this manually within Microsoft Word or perhaps in other PDF editing programs. I want to show you something important in the COI in this sample supplemental filing. We're looking now at page 4 of the State Department's Human Rights Report, which you may recall our hypothetical applicant from Eritrea referenced in their personal statement. They said that the Human Rights Report discusses prison conditions at page 4, which is located at page 7 of my supplemental filing. Well, here it is. This is page 7 of the supplemental filing. And notice what I've done. I've highlighted the exact language that I want the officer to pay attention to. I've highlighted the parts that I think are most relevant to the applicant's case. And you'll definitely want to do this in your supplemental filing. You need to highlight the most important language in the resource that you're providing to the officer. If you literally quote something from the COI, you need to highlight that language that you've quoted in your personal statement. Now, how do you make these highlights? Well, BundleDocs has a feature that allows you to manipulate, including by highlighting the PDFs that you upload to it. But you can do this with other PDF programs as well. For example, if you have a Mac computer, you can highlight PDFs in the preview program. You can do this in Adobe Acrobat, as well as a service that I like called Small PDF. I recommend doing these highlights electronically rather than printing a supplemental filing out and then using an actual highlighter to physically highlight the relevant portions. Now, why is that? Well, as I'll explain later, you're going to send this supplemental filing to the asylum office by email, and you want the highlights to show up in the electronic version of the filing in the PDF that you'll send by email. All right, let's go back to how to package the COI. You can see in the index for the sample supplemental filing for the applicant from Eritrea that the Human Rights Report is found at pages 4 through 8. Do you remember how many pages of the report actually was? That's right, it was 26 pages. So why did I include only 5 pages of it in this supplemental filing? Well, you see, you only want to include the relevant portions of reports. So if it's a news article you're including, then sure, go ahead and include the whole thing, even if it's several pages long and not all of it is relevant to your case. But for reports, I recommend just using the relevant portions. Some of these are long and you do not want to bury the asylum officer in paper. Even the sight of a massive asylum case file can cause stress in the asylum officer, causing them to think, you know what, this is just too hard, and to mentally check out. They're less likely to give your case the attention it deserves if it's simply overwhelming in volume. For COI reports, I recommend including the cover page of the report, if there is one, and the table of contents or index, if there is one. Then skip to the first section in which you have highlighted language that you want the officer to see. Include that whole section, or if it's super long, find a good natural seeming cutoff point and end it there. Then jump to the next section that you quote or reference in your personal statement and do the same thing. Next, string all these parts together into a single PDF using some kind of PDF manipulation software. Yes, you may end up with a PDF for this COI source that has massive gaps in it, but I think that's better than including a huge report in which only a few pages are directly on point for your case. Note that each COI source should be included as a separate element in your supplemental filing. By that I mean you should not just have a generic COI section where one report runs into the next without an index to show the officer on what exact page each separate resource starts. Rather, each resource should be clearly labeled, and it should be clear where within your COI section it starts. That's what I've done here in this example, where we've got 2 COI sources, the Human Rights Report and then a report from a human rights organization called Amnesty International. Okay, so now you know how to properly compile COI and how to build out your supplemental filing in a way that provides pagination and an index that makes it easier for the officer to handle it all. But what about the sources? Where should you be going to look for authoritative COI that the officer will trust? How can you make the greatest possible impact on the officer through your selection of the best resources? Well, we've been talking about the Human Rights Report, and that's one you should always consider using. But what else? Well, as a general rule, you want to stick to mainstream resources, things that the officer is familiar with, which won't cause them to think, wait, isn't that group that published that report some crazy extremist group way out there on the fringes? I want to share with you now a few good sources for COI, many of which asylum officers are actually taught in their training to use in doing their own research. You may want to start with this link, which is a website of the U.S. immigration court system where they've already aggregated certain reports for most countries. You click on your country and it shows you a bunch of relevant reports for it. Here, for example, is the page for Eritrea, where they've got links to various years of the Human Rights Report and foreign government reports and non-governmental organization reports. You can see the names of several NGOs that are widely respected: Amnesty International, Human Rights Watch, and Freedom House. You should also consider Googling the name of each of these organizations, followed by your country's name, to find reports by these organizations about your country. Note that over on the left side of the webpage, there are links for resources divided up by topic. For example, there's one on female genital mutilation. So if you're from Eritrea and your case was about that, you would definitely want to click that link to see what information is provided. You should also check out these two sites that pull in lots of reports and organize them in a helpful way. They're called RefWorld and ECOI.net. They're excellent resources. Remember how a page we looked at a minute ago had a link to reports by the UK government? Well, that's because certain other countries produce reports similar to the US government's Human Rights Report, and these can definitely serve as useful COI. And here, for example, you can find reports from Norway, and here's Australia, and over here we've got Canada, and here is the United Kingdom. We've been talking mostly about reports from governments and NGOs, but traditional news articles may be helpful as well. I recommend the following outlets: the New York Times, the Washington Post, Al Jazeera, the BBC, the Wall Street Journal, the Guardian, Bloomberg, and Reuters. These are all sources an asylum officer will be familiar with and will likely trust. They also do good reporting on international affairs, so they may have stories relevant to your case. Note that you should also simply Google for COI. Search using your country's name plus things relevant to your claim, like, for example, Eritrea, persecution of political dissidents. How much COI should you provide? Well, I can't give you a firm answer on this. You just need to provide as much as is necessary to show the officer what they need to know about your country. It is possible to overdo it. You do not need to include 5 different resources in support of the proposition that the police in your country are corrupt and can't be counted on to take reports of the kind of harm you fear seriously. I'd say 2 or maybe 3 sources that drive home that point will be plenty. Okay, now you know what kind of COI may help you, where to find it, and how to present it. So we're ready for the next and final element of the supplemental filing: evidence. By evidence, I mean any item that is directly related to your personal circumstances that supports your case. The COI we just talked about is more general in nature, and it addresses what's going on in your country. Evidence, by contrast, is more closely tied to you personally. You may have submitted evidence with your application that helps to prove that what you're saying happened to you did in fact happen, or that you're at risk of being harmed in the future. But there's almost certainly more that you can get in support of your case now that you know about the CHIPS framework, which you learned about in my training, the CHIPS framework for asylum success. At this point, after getting this far in your asylum interview training, you have a better overall understanding of how asylum works and what you need to show the officer so they can grant you asylum. Also, there may have been things that have happened since you submitted your application that the officer needs to know about and for which you're able to get evidence. For example, the people you fear may have gone to your home or to your neighbors back in your country and asked about you, or threatened you even. Said something like, tell them that we're going to kill them if they ever come back. Well, that's relevant to your case, and if you can get proof of it, it could help you. For example, a written statement from the person to whom this threat was told could be helpful, as would any screenshots of any threats made over social media or SMS. But let's take a step back and discuss what kind of evidence may be helpful. What should you try to get? Well, first of all, consider every incident of harm and every threat that you've endured, and then ask yourself this question. Is there anyone with personal knowledge of this incident that could write a letter about it, or is there any documentary evidence that helps prove that the incident did in fact occur? You see, the main purpose of evidence is to back up what you're saying in terms of things that you're claiming have happened. Evidence is not required to prove the existence of a fact, but it can help. So if you can get something that backs up what you're saying happened, then you should try to do so. Now, let me give you a couple of examples to show you what kind of evidence is most commonly provided and which can be helpful, and then I'll say a few words about the format and presentation of it. Let's go back to our sample case of the applicant from Eritrea. Remember how they were detained and threatened? Well, if there was someone who witnessed this, meaning they have personal knowledge about what happened, then our applicant should try to get a letter from that witness, assuming they know them and think they can get this done without putting anyone in danger. And this is an important point. Evidence is not important enough at the asylum office for you to put anyone in danger in trying to get it, okay? If you think that asking for it might put someone at risk, then just go without it. Remember, you can win asylum without any documentary evidence whatsoever, as long as your testimony, what you say at your interview, is detailed, consistent, and plausible. Now, back to our witness's letter. What should go in it? Well, it should focus on precisely what they saw and heard during the applicant's detention. For example, it could be something like, Ron and I have been best friends since we were children, and we were together at the protest against the government when the authorities arrested both of us and took us to the detention center. We were held in the same cell, and when we were finally released, one of the guards pulled him to the side and talked to him directly. It was about 4 feet away, and I could hear clearly what was being said. The guard said to him something along the lines of, "You're lucky that we're going to let you out this time, but if we ever see you again, we're going to imprison you and then throw away the key. We'll do unspeakable things to you because you deserve it, because you oppose the government." I don't remember the exact words the guard used, but it was definitely something very close to that. Okay, so you're getting a sense for how this works, right? Now, should this witness, let's call him Bill, talk about other stuff in this letter? Well, recall that he said they'd been friends for a long time and the two of them were arrested together while protesting the government. It sounds like Bill might be familiar with our applicant's political activities. By the way, let's give our applicant a name. Let's call him Ron. Information about Ron's political activities are probably relevant to his case, since the guard in detention threatened him because the guard thought Ron opposed the government. Also, Bill and Ron were detained while protesting the government. So yeah, any details that Bill can give in his statement that show that, yes, Ron has been actively involved in opposition politics would be helpful. This would help to establish that Ron possesses one of the 5 protected asylum characteristics, a political opinion, and it's also what's causing the government to target him for harm. But you see, in speaking to Ron's political activities and political opinion, Bill's letter should not just say, Ron is very active with his political party and he goes to lots of protests against the government because he hates the government. This type of error is very, very common in statements for asylum cases. The writer of a letter isn't telling us how they know these things. The first thought in an asylum officer's mind upon reading Bill's letter would be, how do you know that? This isn't how your witnesses should write their letters. Instead, they need to point to facts about which they have personal knowledge. For example, if Bill, our witness, knows that Ron attended lots of protests because Bill also attended them and he saw Ron at them, then Bill should say as much in his letter. For example, he could say, I have personally participated in at least 10 protests against the government with Ron. The first one we attended together was around October 2020, and the last was the day we were detained on May 20th, 2022. At most of the protests we attended together, Ron wore the shirt of the opposition political party we support, and he carried a sign we made together that said, "Down with the corrupt government." Now that, you see, is something that really gives the asylum officer useful facts from what sounds like a reliable witness. Now, what about something the person writing the letter is pretty sure happened to you, but they didn't literally see or hear actually occurring? For example, let's say that during the detention, Bill saw a guard take Ron out of the common cell and go through a room, and they closed the door behind them. A few minutes later, Ron returned to the common cell bloodied and limping. Should Bill talk about this in his letter, even though he didn't see the attack? Yes, he should explain what he did see, and he could say something like, when he came back, Ron had blood pouring out of his nose and had a really hard time even walking back to the bench in the cell. I asked what happened, and he said that 3 of the guards had beaten him up. Now, a couple of words on formatting and transmission of witness statements. Keep them short, okay? I recommend that you advise people writing them to limit them to a single page. The writer should state their full name and ideally include a PDF copy of their passport data page, which can go on the page after the letter itself. They should sign and date the letter. Letters from witnesses do not need to be notarized. Now, how should they get it to you? Well, emailing you a PDF version is fine, but this should be a scanned copy of an original that contains a wet ink signature. What do I mean by that? I mean the writer of the letter actually signed it with an ink pen rather than applied a digital or electronic signature, and then they scanned the page that contained that ink signature, creating a PDF that they then email to you. If someone sends you a physical letter by post, or in fact, if you get any kind of evidence by post, you should keep the envelope or the package that it came in and take it along with the original evidence inside it to your asylum interview. Officers sometimes ask to see the envelope in which a piece of evidence purportedly came. If someone emails you evidence, do you need to print out and take with you the actual email itself or just the attachment, which is the evidence? The latter, meaning just the evidence, is fine in my opinion. Let me address quickly a question I often get about witnesses. Will USCIS contact them? Like, will the US government reach out to them and ask them questions about your case? No, almost certainly they will not. I believe the chances of this happening are so low that you should not worry about it at all. Okay, so we've talked about getting a witness letter from people who can confirm facts that are important to your case. What other kind of evidence should you try to get? If you've been harmed and sought medical treatment, definitely try to get documentary evidence of this. Like if you can get a doctor's note or even a receipt that shows that you paid for a hospital visit, this can be helpful. If you have photos of injuries in the aftermath of an attack, like pictures showing you with a black eye, a lump on your head, or whatever the case may be, include those as evidence. Threatening SMS or social media messages are of course relevant and should be included, as should any messages or photo that demonstrate that you possess the protected ground that you claim to possess. This is especially important in cases where the whole case depends on your possession of the characteristic, in the sense that if you really do possess it, you'll almost certainly win asylum because people who possess it are so widely persecuted in your country. So to go back to examples we've touched on previously, an Iranian who has converted from Islam should provide evidence that they have in fact converted. They should look for documents, messages, and photos that tend to indicate, yes, this person really does hold the religion that they say they converted to. The same for a sexual minority, by which I mean anyone who's not straight. As messed up as this is, they do need to convince the officer that they're a sexual minority, and they should therefore try to get evidence, as strange as that sounds. So what else should you get evidence for? If you suffered psychologically as a result of the harm you endured, you should try to get evidence of this. A letter from a mental health professional whom you've seen can be powerful. If you continue to have physical problems because of the persecution, like perhaps pain or even a physical disability, then getting a doctor to document this could help. You may need to provide documentary evidence regarding immigration matters. For example, if you were in a third country after departing your own country but before entering the United States and you had a tourist status there, it would be a good idea to include a copy of your visa and the passport stamp that you got upon entering that country that shows that you had tourist and not permanent status. This is for the purpose of addressing the issue of firm resettlement, which we touched on earlier. I unfortunately can't make an exhaustive list of the different types of evidence that could be helpful for an asylum applicant. Just let your guiding principle be this. If it helps address any of the elements of the CHIPS framework, then you should try to get it. Okay, how much evidence do you need? Well, as with COI, there's no set rule and every case is different. If it helps support your case and you can get it, then you should probably include it. But you do not need 30 pictures of you at your baptism to show that you embraced Christianity, for example. 2 or 3 will be fine. Likewise, you do not need 10 letters from people talking about the exact same incident and saying pretty much the exact same things. I would say that 2 is sufficient. And in fact, 1 is probably fine as well. We're about to talk about how to package the evidence and the rest of the elements of the supplemental filing. But first, quickly, let me stress that you need to review all the evidence carefully before deciding to actually use it. Check for inconsistencies among pieces of evidence and your own declaration and application materials. If there are inconsistencies or if something just seems weird, you'll need to sort this out. It may mean that one of you or someone else, are misremembering something, like perhaps a date or some other detail, and you need to get to the bottom of it. You don't want to send in stuff that contains inconsistencies unless you've got a really good reason to need the evidence and you've got a good, innocent explanation for the inconsistencies. All right, I recommend putting the evidence in chronological order in your supplemental filing. You can see I've done that in our Eritrean example, which are all 2022 dates. It goes May 20th, a generic May date, then May 25th, and finally June 1. So once you've got your evidence sorted, the last item that you need is a cover letter. This is a super simple letter saying something like, my asylum case is pending with your office, and I'm writing to request that you please include in my file for the asylum officer's consideration the attached materials. This filing consists of a written declaration by me, country of origin information, and evidence. Please let me know if you have any questions. And next, you're ready to put the cover letter on top of the supplemental filing packet. You can do this, merge two PDFs, with one of them the cover letter and the other the 3 elements of the supplemental filing with various PDF manipulation tools, including small PDF, Adobe, and Bundle Docs. Now, at this stage, you've got the filing already in PDF format. But if it's large, like if it's a lot of pages, you may need to compress it using PDF management software so that you can attach it to an email. Email services will not let you attach massive files. If you applied for asylum on paper, you're going to need to print the PDF that is your entire supplemental filing, including the cover letter, and send it by physical post to the asylum office. If you applied for asylum online through the MyUSCIS website, then you would upload all of this through your MyUSCIS portal as supplemental documents. In that case, you do not need to send a physical version by post. But when should you send this supplemental filing? Like if your interview hasn't yet been scheduled, do you go ahead and send it as soon as you compile it? Or should you wait until you get your interview notice in the mail, or what? Well, I recommend sending it right away once you've got everything ready. Just getting in touch with the asylum office in this way through your supplemental filing might be enough to spur them to schedule your interview. Okay, are you ready to learn about what I think is a clever move that can really help the asylum officer and which almost no one ever does? All right. You need to email your supplemental filing to the asylum office after you get your interview notice, which will be probably around 2 weeks before the actual interview day. Send it to the generic email address for the asylum office and explain that it's a supplemental filing for your case, that you have an interview scheduled, and that you ask that they please forward your message and the attachment to the asylum officer assigned to your interview. That way, the officer will get the filing in PDF format, which is much, much easier for them to actually use than a physical version of it. Believe me, it makes the officer's job easier if they can see what is essentially your whole case, everything they need to know in a single document on their computer screen. Do this, and the officer will love you for it, okay? Okay, folks, that's it. This concludes the training. Thanks for sticking with me to the very end. It's an honor to support you in your asylum journey.